10%. Let's see if we can get this resolved.
Sir, I'm indigent right now. I don't have the $500, and I've just done 9 months. I'll be sitting in here on a $500 bond for this case.
All right, this is going to be an arraignment. Mr. Gibbons?
Yes, sir.
All right, state your name for the record if you would, sir.
Matthew Jonathan Gibbons.
Okay. Sir, you are before the court on a 2-count complaint that alleges that on or about December 3rd, 2021, at the location of the Meyer store in Pittsfield Township, Washtenaw County, state of Michigan, that you did commit the offense of larceny, $200 or more, but less than $1,000. Do you understand the nature of that charge, sir?
Yes, sir.
All right. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, I do, sir.
Count 2 alleges the charge of receipt and concealment of stolen property, $200 or more, but less than $1,000. That's also a misdemeanor, punishable by up to 1 year, $2,000 fine plus court costs, or 3 times the value of the property. You understand that?
Yes, I do, sir.
All right. So, sir, first of all, I'll ask you, do you wish to be represented by an attorney?
Yes.
All right. This is a public defender case.
And Your Honor, is also a state matter. So Caitlin Kirby on behalf of the people.
Oh, I'm sorry. It didn't give you a chance to. All right.
I'll take it, Melissa. Andrew Meyer on behalf of Matthew Gibbons. At this time, we waive any further readings of charge. Ask that the court enter plea of mute to all the charges. We would request a personal bond for these matters. I didn't have an opportunity to see if there was anything else holding Mr. Gibbons at this time.
I get out next Thursday.
I'm sorry?
I get out next Thursday.
Okay, so he's sentenced, so it would just be a matter of him completing his sentence.
Your Honor,
so
he has 2 holds. He has a hold out of Van Buren Township, and he has a hold out of Dearborn Heights. So he has 2 holds, and then he does have his felony case that, if that's what he's referring to, that's what he's getting out on. But he also has a 14-2 case where he was remanded. So he's held on that case as well.
Okay. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pre-trial in this matter will be adjourned to the 18th. We'll give it 10%. Let's see if we can get this resolved.
Sir, I'm indigent right now. I don't have the $500, and I've just done 9 months. I'll be sitting in here on a $500 bond for this case. Can I please have a personal?
That is not my understanding. Did you hear what the prosecutor just indicated?
It's for a driving unsuspended and for a littering charge.
I don't know what they're for, but my understanding is you have 3 holds. You have 2 that are out of county, and you have 1 that's holding you in county.
I understand, but they always let me go on a personal recognizance for the other 2 cases. They will let me go. So if you give me a PR, I will be out of here on the 12th, and then I will return to court like I always.
You got to hold before Judge Tabby. My understanding is the 12th is the sentencing on your felony. Right?
No, I'm already sentenced. I'm already sentenced, and I'm ready to go. I'm getting out on the 12th. I've just done 9 months. I need to get out of here and start working, sir, to pay my restitution, please.
He is sentenced on the felony, Your Honor. I do believe he's set to be released from those cases on the 12th after serving 9 months, but then he has the 3 other holds.
Which is one is
that's what I'm indicating.
One is a driving unsuspended.
I can give you a PR. You're not going to go anywhere, and then you get any credit against this case if that's what you want me to do. But I don't think that you're a lawyer. So, Mr. Meyer, what do you want me to do?
Please give me a PR.
I don't care what you're saying, Mr. Meyer.
Your Honor, if I do believe Mr. Gibbons was before Judge Tabby last week, and if he was remanded, Mr. Gibbons, that's not going to matter because Judge Tabby isn't back for 2 weeks.
Can I have a $100 bond then that I can afford?
You know, I don't know. You're not getting out. You can post this bond. Are you even listening to what everybody's saying?
I understand, but
but you're not listening because I'm going to give you a date before you actually get back to 14-2. Okay, and that way you actually get credit. Do you
Well,
even understand that? Or are
I
you just
understand, but
talking?
For
Or
a
are you
hundred,
just talking?
for $100 bond, I can get out if I got the chance.
You won't go anywhere.
Well, can we make that just in case?
No, I'm not negotiating with you. 5,000, 10%.
That's not fair, Your Honor.
You want me to really be unfair? I can do
No,
that.
I don't. I really would ask
Okay.
that you please just give me $100 bond.
I think what you ought to do is just be quiet. You're actually going to get credit. I'll give you a PR. Then you don't get any credit in this
Can you
case.
give me a
Then you're
PR
going to
then?
get out. And if there's a plea, then you're going to get thrown back in. I don't even understand why you're asking what you're asking.
Because I know that I'm getting
no
out.
sense.
Well, then can I
Mr. Gibbons,
please just get a PR?
Just hold on, all right? Because
I would like a PR, sir. Because I know I'm getting out on the 12th.
What is his date before Judge Tabby?
Your Honor, I'm checking that. If the court could just bear with me, it took me a minute to get onto the system.
Because he's off for 2 weeks, like you said. And so I
Right.
don't think he's
It
going to
can't be any earlier than next 2 weeks from now.
Yeah, but I got an early release. I got an early release.
Mr. Givings, should you please stop? You're not helping yourself.
Pete.
Just a moment, Your Honor. I'm just having a little trouble pulling
No, it's
the
okay.
status sheet up.
Makes no sense.
Your Honor, I
Judge,
can
if
call
I
the
may,
court.
Yeah, go ahead.
I've only found one case under Judge Tabby, and for this defendant, he
Okay.
is set for sentencing on that case.
He doesn't, so he's been remanded till September 12th on that case. At this point, is that right?
That is what I am seeing in
I'm
JIS.
not remanded. There's no other case.
Sir, stop. Ms. Tang,
Your
you were
Honor.
saying? Yes, go
Well,
ahead.
I apologize, Judge. The case before Judge Tabby, he is to be released on May 12th.
So,
On May 12th.
yes, so it looks like it's a DWLS. There was a conditional sentencing, so he can clear up his license, which is why it's set in September. And it does say that he can be released when his release from his felony cases are. So he would just have the 2 holds from the other counties. But he is being held till then.
Am I muted?
In light of that, and given that the court date wouldn't be to the following week, I think
Got it. So I'll give him the 18th. I'm going to give him a PR. He needs to understand he's not getting any credit against this case. So
That's fine with me,
you
sir.
don't get, I don't care. Stop talking.
Sorry.
He needs to understand, Mr. Myers, he's getting no credit. And really, in terms of his behavior today, has not done himself any favors with this judge. And he needs to really understand that. I'm
Sure.
done. Get him out.
I'll be sure to speak to Mr. Givings about that.
Get him out.
I appreciate the court giving us the opportunity to clear that up.
What should have been a straightforward arraignment quickly turned into a lesson on why listening matters in court. As the judge, attorneys, and court staff worked to untangle the defendant's custody status, the defendant repeatedly interrupted and argued for a lower bond, despite multiple explanations that his other holds would prevent his release anyway. Eventually, after the court clarified the confusion surrounding his pending cases, the judge granted a personal bond. But the hearing ended with a clear warning. Courtroom behavior can influence how a judge views a defendant, and patience often accomplishes more than constant interruptions. In the end, the defendant got the outcome he wanted, but not before testing the court's patience.